Summary of TCC Judgment 111 宪判 16 2022 Urine Specimen Collection by Judicial Police Officer. High notes. In this judgment, TCC declared Article 205-2 of the Code of Criminal Procedure unconstitutional. The TCC ruled that the said provision, by empowering the public prosecuting affairs official, judicial police office, or judicial policeman to collect urine specimens against the accused or the suspect's will for criminal evidence without written permission signed by a public prosecutor fails to satisfy the requirement of due process, consequently infringes upon the suspect's right to information privacy and freedom from bodily and mental harm. Background note. The petition of this case was filed by the Criminal Division No. 17 of the Taiwan New Taipei District Court in hearing a drug offense case. The petitioner believed that the pertaining Article 205-2 of the Code of Criminal Procedure has violated the Constitution. The petitioner suspended the proceeding of the case and lodged a petition regarding the constitutionality of the disputed provision with the Judicial Yuan in 2014. Summary of the judgment holding. 1. Article 205-2 of the Code of Criminal Procedure stipulates that a public prosecuting affairs official, judicial police officer, or judicial policeman may, for the purposes of investigating the circumstances of an offense and collecting evidence, if necessary, gather against the suspect's will samples of urine, if there is a probable cause to believe that the samples can be used as the evidence of crime. The disputed provision can only be construed as the authorization of the prosecuting affairs official, judicial police officer, or judicial policeman to gather urine specimens through non-invasive measures. However, even so construed, said provision does not adhere to the due process required by the Constitution, consequently violating the suspect's right to information privacy and freedom from bodily and mental harm protected under Article 22 of the Constitution. The disputed provision shall cease to be enforced after 2 years from the announcement of this judgment. For open cases that have conducted urine specimen collection following the disputed provision before the announcement of this judgment, current regulation shall still apply. 2. The competent authority shall amend the pertaining provision as appropriate within a 2-year grace period, during which non-invasive urine specimen collection under the disputed provision shall require prior written permission from the public prosecutor. Where the situation is urgent, urine specimen collection under the disputed provision shall be reported to and permitted by public prosecutor within 24 hours of its enforcement. If deemed impermissible, the prosecutor may revoke the action within 3 days. The suspect who is subject to the said measure may appeal to the court for revocation within 10 days. Reasoning. Under the disputed provision, the collection of urine specimens is conducted on the human body to perpetuate criminal evidence, which amounts to physical examination in the criminal procedure, and has the same compulsory nature as the search under Chapter 11, Part 1 of the Code of Criminal Procedure. The compulsory collection of urine specimen may be divided into 2 categories in terms of its method: invasive and non-invasive. The 2 types of measures essentially cause the same amount of infringement on the suspect's information privacy. They both acquire information on the suspect's behavior, personal life, through data contained in the urine specimens. However, for the reason that invasive urine specimen collection is enforced through the method of inserting a catheter compulsorily in the suspect's private part, during which the suspect's right to information privacy and freedom from bodily and mental harm will be violated severely. Furthermore, as invasive urine specimen collection imposes severe infringement on the legal arrested suspect's fundamental right, it is unreasonable, illegitimate, and in conflict with the due process to authorize judicial police officer or judicial policeman to enforce it. Therefore, the disputed provision shall be applied only to the urine specimen collection through a non-invasive method. The suspect's information privacy and bodily freedom will inevitably be violated even though his urine specimen is collected through a non-invasive method. Therefore, evidence perpetuation through non-invasive urine specimen collection shall follow the necessary procedure to conform to the requirement of the due process of law under the Constitution. Given the stated measures non-consensual criminal investigative nature, its authorizing provision, in order to be constitutional, it shall adhere to the equal standard of due process as other similar physical examination of a compulsory nature. Considering the collection of urine specimens causes less damage to the suspect's information privacy compared to the collection of blood samples, conferring the public prosecutor with the competence to authorize a non-invasive, non-harmful urine collection and to decide whether to enforce the stated measure non-consensually in individual case, satisfy the requirement of due process under the Constitution. Under the disputed provision and for the purpose of evidence perpetuation, judicial police officer and judicial policeman may, with a prior written permission from the prosecutor, enforce the non-invasive urine collection upon suspects who are legally arrested and detained. Unpermitted non-invasive urine collection by judicial police officer or judicial policeman is lawful only if it is out of urgency for the perpetuation of criminal evidence, and it must be reported and permitted by the public prosecutor as post facto. In the said circumstances, individuals subjected to the stated measure shall have the opportunity to remedy in front of the court. The disputed provision is unconstitutional as it authorizes the judicial police officer or judicial policeman to conduct non-consensual urine specimen collection on the lawfully arrested sans permission from a public prosecutor without specifying its urgency, as it does not require as post facto supervision from a public prosecutor, and as it does not provide remedy for individual subjected to such a measure, rendering it in violation with the due process in protecting the suspect's information privacy and the freedom from bodily and mental harm.